So here we're specifically talking about the multi-state performance test, but I think it's necessary for me to sort of preface this too, before I talk about specifically the multi-state performance test and really sort of give the lay of the land right now, just because, as Mr. Kim talked about, there is sort of this sort of changing landscape with the current uniform bar exam being transitioned over to the NextGen uniform bar exam. It's a little confusing because both exams are technically called the uniform bar exam, but one's called, the current one right now is the legacy uniform bar exam, and the new one is going to be called the NextGen uniform bar exam. And so that transition period is going to begin in July 2026, and it's going to be completed with the, or at least after the administration of the July 2028 exam. Okay. At least for purposes of the online LLM program, graduates of that degree program are eligible to take the exam in Washington State. They're going NextGen Bar Exam in two more administrations, July 26th, DC, and that's actually a typo. Actually, that should be February 2028. I apologize for that. The next slide will make that a little bit clearer. And then there's California also. And there's no date for California just because California creates its own performance test. With that said, I sort of created sort of a handy comparison chart. Again, you know that I like visuals, so I think hopefully this will help you out. And again, I think depending on when you enroll in the program and depending on when you graduate, if you're taking the DC bar exam, okay, the current performance test, which is called the multi-state performance test, is going to be administered through the July 2027 exam. For the February 2028 exam, and if we're only talking about DC, right, they're transitioning to the NextGen UBE. Now, there's still going to be a performance test. There's going to be slight differences, though, but how you attack the performance test and the skills being tested and everything is relatively the same. And in fact, to illustrate that, right, the NextGen performance task is what it's called instead of the multi-state performance test, is really the sample questions that the NCBE has released were actually past MPTs, but just basically cut down or condensed a little bit by reducing an issue. And they're doing that because the multi-state performance test is currently 90 minutes. The performance task, which is sort of the successor to the MPT, is 60 minutes. Currently on the uniform bar exam, the current uniform bar exam, you have two MPTs at 90 minutes each. On the NextGen bar exam, you'll have three performance tasks at 60 minutes each. Again, it's a total of 3 hours. So the work time is relatively the same. A little bit more interesting about this is that even though the amount of time you'll actually be working on these performance tests or performance tasks, depending on the uniform bar exam, even though it's going to be the same time-wise, the weight of these components are going to be significantly different. On the current uniform bar exam, the MPTs, so the two 90-minute tests, are worth 20% total, as opposed to the NextGen bar exam, where these performance tasks are going to be worth a little bit more. They're going to be worth about 30%. Okay, so you'll have three of these tests worth 30%, and you'll have three of these tests that are going to be 60 minutes each. Okay. And one of the reasons for the greater weight is that you'll have more of your seat time actually working on the NextGen bar exam, which is a day and a half, versus the current bar exam, which is a full 2 days. Now, those are sort of sort of the logistics about sort of the differences between the current MPT and the successor performance test. And that, again, the skills are going to be relatively the same. The format's going to be relatively the same. So let's talk about like what is the MPT, right? And so when you think about the MPT, the multi-state performance test, what the examiner said is that, look, this is really like the part of the exam that most simulates real life practice. And so this part of the exam, what the examiners will do is that they'll give you a set of materials, usually about 15 to 25 pages. And in that packet, the examiners will give you all of the facts that you need to know and all of the law that you need to know. And it is your job to go through those 15 to 25 pages of really dense materials. And we'll go through a full packet to sort of see how much information is actually provided to you. And it's your job to go through those materials to think about, how do I complete, whatever that real world lawyering task is asked of me, whether it's writing a internal memo to a supervising attorney, whether it's writing a memorandum of law to the court, whether it's writing a letter to maybe your client or maybe to opposing counsel, right? So, and that's one of the reasons why the NCBE, the examiners who write the MPT, that's why they say this most simulates real life practice, because you're actually given a particular task to complete. Now, obviously, that's what they say. Real life task is not meant to be done closed book in 90 minutes, right? So obviously there are some artificial things there, but because you are going through 15 to 25 pages completing a lawyer-like task, timing and going through the materials in an efficient way is so important. So that's the format. Now, if we sort of dive a little bit deeper, okay, when you have these 15 to 25 pages of materials, those materials are sort of broken down into sort of two different parts. It's divided into the file section and it's divided into the library section. And so let's talk about the file section first. And an easy way to sort of think about those two sections, right? The file section versus the library section. The file section, because it starts with an F, right, includes all the facts you need to know. The library section, because it starts with an L, contains all the law that you need to know. Okay. And so when we look at the file, the first page of the file section is what's called the task memorandum. Okay. Now, the task memorandum is probably the most important document in the entire MPT packet. Why? Well, it's that task memorandum that tells you what your assignment is. It tells you who you're writing for. It tells you what to do, and it can tell you sort of what not to do as well. And that task memorandum is usually a memo, right, written by your supervising attorney, directed specifically to you, telling you sort of the background of the case and what you need to know. And we'll go through a sample task memorandum. Now, that's only one part of the file. Other things you may see in the file, maybe some drafting guidelines. So sometimes the file will tell you how to format a particular response, right? There are some documents that the examiners expect you to already know how to format, like a client letter, like a memo to a supervising attorney, like a persuasive brief. But there may be other things that the examiners may ask you to create, like draft a statute, draft interrogatories, draft deposition questions, draft a closing argument, right? There may be some tasks that might be unfamiliar to most people. And so in that case, the examiners may give drafting guidelines to explain how a particular task or work product should be created. Now the file, again, file means facts. So the file section will include other factual documents. It may include interviews with your client or other witnesses. It may include complaints. It may include transcripts of other interviews, reports, records, news articles. One of the examples that we'll see includes a marriage license, right? It can be any sort of facts. Okay. Now, some of the facts may be relevant. Some of the facts may be irrelevant. And so part of what's required for you is to go through the materials and figure out, okay, what's relevant, what's not. Okay? Now, the library is the section of this 15 to 25 page test packet that gives you all the law. Now, one of the things about the MPT is, again, they give you all the law. So anything that you know about a particular area of law that may be part of the MPT, just forget it, okay? Because sometimes it may be different than the law that's specifically given to you. So that's why it's so important to read carefully all of the statutes, cases, rules, regulation, acts that are given to you in the library, because I've seen that there might be something in the library that is slightly different than maybe what you have known by studying that subject in a different course. A good example there is there was once an MPT where the library gave students some excerpts from the Franklin Rules of Evidence, and it talked about sort of this exception to the hearsay rule called the dying declaration rule. And there are some exceptions to the dying declaration rule that did not apply under the Franklin Rules of Evidence that actually did apply under the federal rules of evidence, which students needed to know for other parts of the exam. Okay, so the library includes all the information given to you. So when you think about it, the MPT seems easy because you have nothing to memorize. I mean, how do you study for it? You don't study for it as like you would criminal law or criminal procedure or civil procedure, right? There's no law to memorize because the test is really testing core sort of fundamental lawyering skills, right? And so you can't memorize skills, but you can work on skills. Okay. As much as I hate to say it sometimes, some people can cram knowledge. One cannot cram skills. And so skills takes time to develop. And it's one of those things that really sort of begins with the early part of the program and continues throughout all of the courses in the online LLM program. And so a lot of the skills that the MPT focuses on are problem solving, issue spotting, legal analysis, and reasoning. Again, specific courses in the online LLM program that really focuses on that. Factual analysis, right? Again, you're given a file with information that may be relevant and irrelevant. So you're going to have to sort of do that determination going through the file. Written communication, right? Not only can you sort of just generally write an essay, but you got to figure out, okay, how do I change it if I'm writing to a supervising attorney versus writing it to a client who may not know anything about the law? Or how do I write something to a judge that may require a little bit more professionalism? Okay. How do you write sort of a quick email to opposing counsel to sort of urge opposing counsel to accept a settlement offer, right? So written communication, not just to audiences, but also the type and tone. Are you writing an objective, sort of well-balanced piece to a supervising attorney or to a client to determine, sort of which sort of position to take? Or are you writing sort of a persuasive brief to convince a jury to take your position? Other skills tested, organization and time management. And again, time management is major. Again, you only have 90 minutes on these MPTs for the legacy UBE. And again, sometimes there will be some professional responsibility issues sort of interweaved within some of the core issues being tested. Again, you're not expected to bring in outside knowledge. So if there are sort of ethical issues involved, then you'll be provided information regarding that. So, I talked about some of the common task types, right? There are some priorities. What we've seen recently, and I've gone through every single MPT since 2000. And so the highest frequency kind of task are the objective memos, sort of the, say, internal memos written to a supervising attorney where the supervising has asked you sort of to take a position on something or what the outcome should be, or a persuasive brief, maybe a document sent to a court. Some things that are sort of mid-range might be an opinion letter to a client, which again would be sort of more objective, or a demand letter to opposing party, which again would be more persuasive. And then there's other things that have been tested historically, although some of these things haven't really been tested over the last, several years. We have bench memos. We have like drafting a complaint, closing argument, redrafting a portion of a contract, right? There can be other things there. So again, if it's one of these things that are less common, like drafting a complaint, maybe redrafting a contract, usually there will be sort of those drafting guidelines in the facts that tell you how to create those things. As far as scoring, and these are relatively the same when it comes to the regular 30-minute essays. Most jurisdictions use the 0 to 6 scale. Sometimes they'll use 0 to 7, sometimes 80 to 100. The main thing to sort of think about is regardless of what the scale is on the jurisdiction, really what you're thinking about is sort of just a rank ordering system regardless of what the number is, right? A 5 is better than a 4. An 85 is better than a 70, a 7 is better than a 1. And responses, that's responses are evaluated relative to other examinees' work. And I will say, again, I've been doing this for over 20 years. I will say one of the biggest problems on the MPT is finishing. There's a lot of information to sort of go through the material. So how do you go through the material just a little bit faster? Again, I only have a couple minutes left here, but like I said before, I think one of the most important parts of the entire 15 to 25 page test packet is that task memorandum, right? It's that first page right after sort of the beginning of the file section. It's really sort of your instruction sheet, right? And so here, I know it's sort of hard to see. Let me just go forward a little bit if I can. I don't know if I have that, but so let me just read this. So this is, again, the task memorandum that tells you what to do. We represent Jennifer Butler in a suit against Robert Hill seeking a divorce and property distribution. Jennifer and Robert have 2 children, temporary custody and child support orders that are in place that are not currently at issue. Robert has challenged the validity of the party's underlying marriage. If there is no marriage, Jennifer cannot pursue a claim for divorce or a share of marital property. Even if the marriage is valid, Robert claims that the home that Jennifer and the children are living is not marital property, but instead is his individual property. I have attached the relevant material from Jennifer's file. I will meet with her later this week in anticipation of trial. Please help me with the following 2 tasks. Now, let's just, for sake of time, we'll just focus on the first task. First, draft a short memo, which I may use to prepare for my meeting with Jennifer. In the memo, explain whether Jennifer and Robert's September 1, 2003 ceremonial marriage had any legal effect under Family Code, Franklin Family Code 301, except don't write a separate statement of facts, but be sure to incorporate the law and the relevant facts and reach a reasoned conclusion. And so this tells you what to do in that short memo. But again, just like if you recall when I was talking about criminal law, you always want to sort of read the call of the question first and try and get as much information sort of out of it. And so, again, sort of put yourself in the shoes of an actual attorney. Again, that's what the examiners really want you to do. And so, really what you're asking is, did Jennifer and Robert's September 2003 ceremonial marriage have any legal effect under that statute? And really what you want to sort of think about is anticipate first what might be in the library and file. And so what should be going through your head, what are some legal based questions that you want to sort of think about, and so as you see that short memo issue, you want to think about things like, well, what's a ceremonial marriage? Okay, the library should include some information about the ceremonial marriage, the requirements of it. What does 301 say, right? Since the call of the question says that, you want to make sure you identify that in the library. And then, are there other sort of legal-based questions? And that'll help you sort of anticipate what's in the library section a little bit more so you can figure out what's relevant and what's not. And you would do the same thing with like some fact-based questions as well. So you can anticipate what's going to be in the facts section. And so some of those things might be based on just that task memorandum. Like, yeah, that Jennifer and Robert are married and they want a divorce, but more specifically, who's Jennifer, who's Robert? What are the details behind that ceremonial marriage? And what are the requirements of whatever that ceremonial marriage met? And you sort of think about other questions there. Okay. And so, in just the last minute or so, I just want to give you just illustratively what the 15 to 25 pages might look like, right? You'll have sort of the cover sheet, you have the file. This is the task memorandum that we just reviewed. This is still sort of the file section. So this includes a summary or notes from an attorney with the client, okay, interview summary. This is an excerpt of a transcript of a telephone interview with Louisa Milligan. Again, we don't know who Louisa Milligan is at this point, but imagine sort of, again, components of the facts. We have a copy of the marriage certificate. Again, dates and things in there might be important. And then we have a judgment of divorce, right? Again, maybe dates and stuff or, other things, and that might be important. We have the deed of the house because there is some dispute in who gets the house in terms of the property division. And then, here we have sort of a party invitation. You are cordially invited to help us celebrate the 6th wedding anniversary of Jennifer and Robert. Okay. So those are all the materials in the facts. And then the library, right? So the library gives you excerpts of the family Franklin Code. And remember, the call of the question had indications regarding sections 301, and it provides information regarding 301, as well as other kinds of information. And we got sort of common law marriage. We have in 309, we have 410 dealing with separate property, distribution of property. We have a case here, okay, and the cases are relatively short. They're usually going to be either 1 or 2 pages. So we have one case here from the Franklin Court of Appeals, 1996. Here we have another case, Owen versus Watts, Franklin Court of Appeals, 2003, a little bit longer. couple pages. And then we have Charles versus Charles, which again, another Franklin Court of Appeals. So all three cases are Court of Appeals. You always want to sort of think about what court did this opinion come from, because then that will sort of impact the weight or the validity of the case as well as the date of it. Okay. And so those were the different pages. It looks like 19 pages in this particular MPT. But let me just go ahead and just go back one slide and just, or a couple slides, and just end with just some common pitfalls regarding just the library only. And again, 30,000 foot view of the MPT. A lot of times, I think when people go through that library where they give you the legal authority, and recall in this particular example, there were statutes and there were 3 different cases. And I think a lot of times when students read the information in the library, they sort of examine the materials in isolation of one another rather than thinking about, well, how do the cases actually fit together? Another one is not discussing each piece of information. And so, like I said, there's going to be some irrelevant information. But normally, if there's irrelevant information, you're not completely ignoring it. You're really sort of explaining why it's not relevant, right? So everything that's given to you really should end up in your response. You just have to explain sort of why it may not be relevant. And then providing a summary of the legally significant facts of the cases when discussing the cases. And so I think a lot of times when people see those cases from, say, the library, like Hager versus Hager, I think a lot of times what students will do will simply just provide a summary of the court's holding. But it's so important to figure out, okay, why did the court reach that decision based on the facts of this particular case, i.e., Hager? Because really what you're doing in your own response is trying to predict what the answer is by either comparing or contrasting the facts in the file of the MPT test with the facts of the case actually given to you. And you can't necessarily do that analogical reasoning or that compare and contrast if you don't necessarily incorporate and describe the facts of the cases that you've written or you've read in the MPT. Okay. So with that, that's, a very sort of broad overview about the MPT and sort of the transition to sort of the performance task that will happen with the NextGen Bar Exam in DC beginning with the February 2028 bar exam. So apologize for going a little bit over.